We got some breaking news in the James Comey criminal investigation. A new motion has been filed claiming a violation of the Fourth Amendment against illegal search and seizure has been brought by a Columbia law professor whose documents and information on his hard drives, on his computers, and his iPads were at the heart of the prosecution against James Comey. He wants his documents back. He wants his information back. And he wants effectively that the prosecution not be able to use anything that they learned in going through his documents because they violated his privacy, his Fourth Amendment right against illegal search and seizure, and the attorney-client relationship that he had with James Comey because he was an advisor to James Comey. At the same time, we're sitting here wondering when the Trump administration is going to lodge their appeal, take their appeal from Judge Curry, having decided in the last week to fire Lindsay Halligan as the U.S. Attorney in the Eastern District of Virginia, tossing the indictments against Comey and Letitia James, the New York Attorney General, along with it. That was done without prejudice, meaning there could be a new grand jury that's working on indictments, although it's more difficult with Comey, and it got more difficult still with the filing of this motion to effectively quash and return the documents to Professor Richman. I'm going to bring it all together. I'm on a holiday vacation for my birthday, but there's just so much to report on. We got to keep it going here on Legal AF on Tuesday. So let's pick up with Daniel Richman. Judge Curry fires Lindsay Halligan to serve as the U.S. Attorney in the Eastern District of Virginia. A few days later, the Third Circuit Court of Appeals fires Alina Habba as the U.S. Attorney for the District of New Jersey. The Department of Justice is reeling from those decisions, and they've got to decide what to do, when to appeal, and what to do in advance of appealing. What it looks like to people on the ground, including me, is that they're going to try to geek up a new set of indictments against Letitia James, definitely, and perhaps against James Comey, using new grand juries and a new prosecutor not named Lindsay Halligan. Once they get that up and running, then they'll file their appeals. But there's twists and turns here related to James Comey, particularly this new motion that was just filed by Daniel Richman. Daniel Richman, Columbia law professor, but is a very good friend and had worked with James Comey in the Southern District of New York as a prosecutor. He then became a special attorney or special counsel for the FBI director when James Comey was in that position. They had a lot of email traffic, a lot of documents that were sent from Comey to Richman. In fact, as we know from reporting, and it's been admitted by Richman leaked to the New York Times on purpose memos, cover your ass memos created by Comey after Trump ordered him to drop the criminal investigation of Lieutenant General Michael Flynn. And then we had these documents released. In fact, here's Daniel Richman talking about that very issue. Let's play the clip.
When you hear President Obama basically saying FBI Director Comey operated on an innuendo, incomplete information, leaks here, what do you make of that?
Actually, I didn't hear it exactly the way you did it, less as an allegation with regard to the director, more as a general statement that I got to say makes perfect sense. You generally do complete investigations and speak only after them. The only complication here is that the director did announce the completion, and it turned out that the investigation had to be continued because of the new trove of emails. I also have to say that the president was right about being careful about innuendo. The fact that some new emails have been uncovered, which the Bureau has not, at least according to reporting, looked at, means that there are some new emails to look at, nothing more. I mean, I keep reading this swirl of claims about what might be in them and what might not. The director didn't know when he made the statement. It doesn't appear that he's in a position to be clear about it now, but to jump to conclusions that these say anything different from what's already been seen seems kind of strange. So I think the president's right to sort of dial this back. And the only difference being the president's wish that announcing a completion meant completion just didn't happen to be true in this case.
For you, how much is what Comey did about protecting the independence of the FBI and protecting it for whoever comes into the office in a couple of weeks?
I think that is his main focus here. What people seem to forget is there is nothing he could have done once he heard about the emails that would not have political ramifications. To stay silent is to let people assume that the investigation was closed because he had said it was completed.
Now, the Richmond interaction with James Comey then becomes the subject of the indictment that Lindsay Halligan obtains. However, the problem with that is it became clear in a order that was issued by the magistrate judge on the 17th of November that both James Comey and Daniel Richmond's rights were violated by how Lindsay Halligan allowed the FBI to use a no search warrant to go through documents that had been collected 8 years earlier concerning a Hillary Clinton email investigation. They let the new FBI agent just go through it without regard to attorney-client privilege. Remember, Richmond's an attorney. Comey is his lawyer as the client. There's attorney-client privilege, or the Fourth Amendment against illegal search and seizure. They just go back, oh, we have the documents for a different investigation. Oh, let's look at it for this investigation. Judge Fitzgerald, who's the magistrate judge, said that is a complete violation and running roughshod over the Fourth Amendment rights of James Comey and by extension of Daniel Richmond. Daniel Richmond brings the new motion, which has been assigned to Judge Catelli, in order to have his documents, his information returned. If that is still the subject of the indictment that they're working on, a second indictment against James Comey, they're going to lose a giant part of their case because that evidence will effectively be quashed. Let me read to you from the actual motion. Motion for return of property pursuant to Federal Rule of Criminal Procedure 41G, brought by his lawyers. And here's what it has to say. It says, this motion seeks redress for the government's violation of Daniel Richmond's Fourth Amendment rights. Between 2017 and 2020, Richmond, an attorney and law professor with a distinguished record of government service, had various interactions with the government relating to his legal representation of FBI Director James Comey. He allowed the government to image his personal computer for the purpose of identifying and deleting certain sensitive documents and subsequently agreed to a limited search of the image. The government later obtained 4 warrants that authorized additional searches of the image of Professor Richmond's email and his iCloud accounts. But then in 2025, the government violated the warrants that authorized the searches because they failed to identify and segregate responsive materials. Thus, they seized the entirety of the search materials. And the government's conduct deprived Professor Richmond of his constitutional rights and has injured him. And so they want the files back, and that the government be enjoined, stopped from making any further use of the improperly seized or retained materials. Meaning, if he is successful, Richmond, the government's not going to be able to use anything from the Richmond pile of documents to try to re-indict James Comey. Now, there's another James Comey problem, in that the statute of limitations for perjury, lying to Congress, has run. They'd only be able to bring a new one if they're able to ultimately argue that Judge Curry was wrong in her decision last week that Lindsay Halligan was illegal and therefore everything she did was illegal, so that the indictment she obtained was illegal and didn't stop the clock for the statute of limitations. Statute of limitations has run. They can't re-indict. Now, they may try to use a different statute that gives them more time, but it's very difficult for me to sit here right now to tell you what that indictment would look like if they try it. But there is reporting that the government is considering trying a re-indictment of Comey with somebody, a career prosecutor, re-indictment of Letitia James for mortgage fraud. Although, again, I'm not sure this is a walk in the park for the government. There's so much publicity about the vindictive nature of this prosecution. I'm not sure they get a grand jury to return a new indictment against Comey or against Letitia James. We'll have to see what happens with these grand juries. Then they got to find that prosecutor. They'll find a prosecutor somewhere to do it. They already have a number 2 in the office who's been appointed, a semi-retired lawyer that's come in to work with Lindsay Halligan. Maybe he'll put the case on. And we'll see if the indictments come flying out. Then I think from there, they appeal. They've got another almost 3 weeks to file a notice of appeal in the Letitia James and Curry case. So I think their new reporting that's important that you need to know is Alina Habba getting fired so soon after Lindsay Halligan got fired by 2 different courts rocked the Department of Justice. They're not going to immediately file a notice of appeal in those cases until they try the re-indictment route using a new lawyer, not Lindsay Halligan. I think they're not going to try to salvage Lindsay Halligan per se, except to argue that her indictment is not illegal because it's ultimately under the ratification of Pam Bondi, the Attorney General. They need to argue that in order to save the Comey indictment at all because of the statute of limitations having run on the crime. Daniel Richman, in his motion to have Judge Catelli bar the use of his information, could be a death knell to any future prosecution of James Comey as well. Because even though the indictments have been dismissed by Judge Curry because of Lindsay Halligan being illegally appointed, it doesn't mean that the substantive attacks on the prosecution, forget the indictment, the prosecution of Comey and Letitia James aren't going to be considered by the trial court judges in their respective cases. So you've got Judge Nachmanoff for Comey and Judge Walker for Letitia James, who have to ultimately make a decision once there's a proper indictment about whether this prosecution should continue at all, or it is an example of vindictive prosecution. So we got to follow all of this. The next big move is going to be whether I come back and report to you that Comey has been reindicted and on what, and if Letitia James has been reindicted and on what, and by who. And then from there, the appeals, I think, will follow. And we'll be off and running in those world. And then the substance of whether these prosecutions, regardless of who's bringing them, are in fact the result of vindictive prosecution, which means that their constitutional rights have been violated and the indictments should be permanently dismissed with prejudice. That is for another day, sitting with judges Nachmanoff and Walker. I'll continue to follow it all right here. Thanks for being here. Take a minute, hit the free subscribe button, come over to Legal AF Substack and help us. We got a sale going on for my birthday, 30% off for Popok's birthday on an annual subscription at Legal AF Substack. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.